Hi everybody, this is Charles again. Let's go on ahead and get started. Want to again thank you for being on my Wednesday webinar. I enjoy these. Hopefully you do as well. I've got some great announcements for you today that I'm super excited about. So let's go on ahead and get started because we've got a lot of subject matter to cover today. I want to first just remind you all of the offer that we've got for new agents. This is for agents that have newly registered with NetLaw. So it's not necessarily a brand new agent to WFG, but just a brand new agent to NetLaw. So when an agent registers, either through the mobile app or through the web-based app, for the first 30 days that they are basically a part of the NetLaw team, we are going to allow that new agent to offer a buy one, get one free to all of their clients. So for any client that purchases a fully paid plan from that newly registered agent during the first 30 days, they will also get a free plan that they can then gift to someone else. And that includes the agent himself or herself. So if the agent actually purchases a plan for himself or for herself, then they also get the free plan that they can then gift to someone that they love or care about. And I'm going to steal a line from Brian Oleman. So Brian, if you're on, and I'm sure you probably are, I want to apologize, but also thank you for this great concept. I like the line that you used with this, but also there was an agent out in California that I'm stealing the idea from. However, Brian is the one that kind of coined the phrase, and Yvonne out in California is the one that had this fantastic idea, and I shared with you guys last week, and I'm going to share it again this week, the concept of join, own, and share. What Yvonne said that he's doing is actually using this new agent buy one, get one free opportunity as an opportunity to recruit new team members. Meaning that when he's talking to someone and they're interested in purchasing a NetLaw plan, tell them that, if you become a member, if you join the WFG team, if you join my team, you're basically going to get that $100 fee back in the form of the commission plus some from NetLaw, and then you even get a free plan that you can then gift to someone else. So that is just fantastic. That concept, and then Brian's phrasing of that, the join, own, and share, I just love. So I want to kind of push that out to you guys and encourage you to use that same concept to build your teams, especially for those of you that are on a run for a promotion. This is a great way for you to do that. And again, it's exclusive to our brand new agents, and this is just a great way for them to kickstart their career, not only with WFG, but also with NetLaw, for them to build their pipeline of clients so that when they do get their license, if they actually go and get their license, they've got a warm market now, a warm market of clients that they've already provided services to, and that they can go back and talk about, other areas of need that they may have. So make sure you're thinking about that when you're working with people that you are either trying to place a product with or that you're trying to add to your team, because this is a great opportunity for you and a great opportunity for that new potential team member. Now also in March, as hopefully everyone is aware, this is our March Madness Spring Fling Contest. So excited about this. This is a $3,000 contest. This is the largest giveaway that we have ever had. And so far, I tell you what, there's a lot of people that have really jumped on the bandwagon and are way ahead in this contest. And it's super easy to qualify. All you have to do is refer five fully paid plans, so 5 fully paid NetLaw plans before March 31st to be entered into the drawing. Now, for every fully paid plan after 5, your name goes in the drawing again. So very, very easy to do. And I'm super, super excited to let you know that today only, guys, so through midnight Pacific Coast time tonight, for all of you that refer a fully paid plan, those sales will actually count as 2 towards this contest. So that's awesome. So, if you haven't yet gotten, started for the month of March, this is a great way to kind of leapfrog some people that have maybe only sold one plan. So sell a fully paid plan today, and that will count as 2 towards the drawing. So that is just a great opportunity for you guys to kind of, maybe catch up with some of the others or leapfrog, some of the other agents that haven't really gotten started yet with this contest for the month of March. So keep that in mind and spread the word, because again, it's only today through midnight tonight Pacific Coast time. So let's talk a little bit about the plan, what's included. So when you are out there talking to your clients, what you are actually offering them is a comprehensive estate plan. This is the building blocks. This is the foundation of every estate plan. So I don't care who you are, whether you're Charles C. Ballmeyer or you're Bill and Melinda Gates. Every estate plan starts with these documents, and that's something that you really need to keep in mind when you're talking to people out when you're in the field. It includes your last will and testament, probate avoidance revocable living trust, financial power of attorney, medical power of attorney, living will, also known as an advance directive, HIPAA authorization, and the life vault. You all know I love the Life Vault. I hope you love it too. I hope you guys are using it every day in your business. It's a great way for you to gain insight to your clients and their needs that they may have. Also included in the plan is access to our national network of estate planning attorneys. These lawyers are vetted for their experience and expertise in estate planning. These lawyers are not general practitioners. They are not first-year law school graduates. They have significant years of experience and significant expertise in estate planning. Please keep in mind and please make sure that you make your clients completely aware that if they engage these lawyers for their time or services, that there are fees associated with that. These lawyers will charge for their time and their services. It's not included in the net law fee. Please also make your clients aware that if they want to speak with an attorney, they will need to make an appointment. They cannot just call the lawyer and expect the lawyer to pick up the phone and just answer a quick question. That is not how lawyers operate. They don't do things that way. They will definitely make an appointment with you either over the phone or in person to answer any questions that you have, but they have to make an appointment, and more than likely there's going to be a fee associated with that. So just want to make that perfectly clear. Now, what is included in the plan, however, at no additional cost, are documents for your client's spouse. So if your client is married, the spouse can create the same set of documents at no additional charge, and that's just a tremendous value for your clients. So now let's go on ahead and get started on, well, now let me go over the fees for you. Sorry, I thought I took these slides out. To remind you, the fees are for the plan is $500 for the first 12 months. Again, that covers your clients fully. During that time, unlimited changes to those documents as often as they need to, unlimited document storage in the vault. Again, truly unlimited document storage in the vault, so they can store all of their estate planning documents, copies of their deeds, copies of their life insurance policies, account statements, passports, photos, anything like that they can store in the vault. After the first 12 months, if they want to maintain that full access, there is an $8 a month fee beginning in month 13, which is completely optional. The client does not have to do that. If they wish to discontinue, they certainly can. However, they lose the ability to continue to make document changes, and they lose the ability to add new documents to the vault. We do have a reinstatement policy if they decide to reactivate their account later down the road. If it's been less than 60 days, there's no cost to reactivate the account. If it's been 3 to 6 months, it's a $79 fee to reactivate the account, and then $8 a month from that point forward if they wish to keep the account active. If it's been longer than 6 months, however, it's a $250 fee to reactivate the account for 60 days. If they want to keep it active after that point, it's a $8 a month fee from that point forward. So I hope that's pretty clear. If you have any questions about that, you guys know you can always contact us. So let's get started. I want to talk about the differences between revocable trust and irrevocable trust. I've actually done this webinar about a year or so ago, but we've gotten a lot of questions about this of late, and some requests for me to repeat this session, so I thought I would do that today. And so basically what we're going to talk about is many things, and we're going to dive pretty deep today. And I want to make it clear before we do that, that what we're talking about today is truly intended for educational purposes only. You do not have to know all of this stuff to be able to refer the net law plan. This is just to give you more talking points. This is to give you answers so that if you encounter some of these questions in the field, you'll be able to answer those questions and you'll be able to better position the net law product with your clients. So again, don't be afraid. This is not intended to be a requirement that you have to master and this knowledge of this particular area of estate planning. I just want to give you some really good insights between the differences between the two trusts, because you will encounter these questions from time to time, and hopefully this will be able to, give you at least a good foundation so that you can speak intelligently when you're out with your prospects and clients. So again, when you're thinking about trust, when you're thinking about planning, there's really kind of two things that a lot of times you're trying to accomplish. And it may be both things, or it may just be one of the two things. And those are dispositive planning and tax planning. Now, dispositive planning, that's basically just identifying your beneficiaries and the manner in which you want them to benefit from your estate. How do you want them to receive their inheritance and when? That is dispositive planning. And that can be accomplished even with just a last will and testament. It can also be accomplished with a revocable living trust. It can be accomplished with an irrevocable living trust. Now, tax planning, that is when people are concerned with saving federal estate taxes upon death. And that is something that can only be accomplished with a trust. And it could be accomplished with a revocable trust and or with an irrevocable trust. So make sure that you kind of keep those two things in mind. And again, what we're going to be talking about today is federal estate taxes. When you hear the word tax, it can be confusing because there's so many different types of tax, and every different type of tax is almost like a completely different animal. Income taxes and estate taxes are two totally different things. So just keep that in mind as we go along, that I'm talking about federal estate tax. So some of the key issues, and you all, if you've been on my client workshops or if you've seen me present to client-facing groups, you've heard me talk about the first three key estate planning issues. I typically do not talk about the tax planning with the client-facing webinars, because the net law plan does not include any tax planning tools, so I don't want to get them confused. But on this particular session with you all today, I am going to cover that. So really the key issues that most people have in mind when they're thinking about planning are, number one, they want to be able to maintain control of everything, not only their assets, but also their healthcare decisions. And with that control comes financial security. If you're controlling your assets, if you're controlling your wealth, the way those assets are managed, the manner in which those assets are distributed and invested, then you're maintaining financial control, correct? Because you have the ability to benefit not only yourself, but anybody else that you want to benefit from your assets. One of the other issues that is very much a concern for a lot of people, not only upon death, but during their lifetime, is the preservation and management of their assets. And I say that because a lot of times people are not always thinking about management of those assets for their own benefit during their lifetime, because they just, take for granted that if they're alive, they're going to be able to manage their assets and benefit from those at will. That may or may not be the case. With proper planning, they can make sure that they are in control and that they do benefit from their assets in the manner in which they want to while they're living, as well as to make sure that those assets are protected for future generations. And then finally, of course, tax savings, being able to structure your plan in such a way that you can maximize the tax benefits from the tools that are available to you through proper planning. So let's talk a little bit more here. Let's start with the revocable trust. As you know, the revocable living trust is included in the net law plan, is a very important tool to your clients, primarily to your clients for probate avoidance purposes. Now, the revocable trust, as its name indicates, is revocable. and it is revocable by you, the person that has set that trust up. The way the net law trust work is that when you set that trust up, you are your own trustee. So you maintain control. That's one of those key elements. You maintain control, which means you maintain financial security. You are also the one that has the ability to make changes to that document at any time. That kind of brings in that whole revocable element of the trust. Basically, you have the ability to change the terms of that trust at any time and as often as you want to. You can put assets into the name of the trust at any time. You can take assets out of that trust at any time. You can change the beneficiaries of the trust at any time. You can completely revoke or terminate the trust at any time. It is completely at your control. One of the other key benefits of this is the privacy that it brings to you, as opposed to only having a last will and testament. Your last will and testament is subject to court jurisdiction, and it is part of the public record. So if you pass away with assets titled in your individual name alone, those are probate assets, and they're going to be subject to that court supervised process. And that's really regardless of whether you have a will or not. However, with a revocable trust, and by having your assets titled in the name of that trust before you pass away, those assets are going to avoid that public process. They're going to avoid that probate process. They are also going to avoid the fees associated with probate, not only the filing fees and the court costs, but also the attorney costs that are associated with probate. It also gives maximum benefit of management of assets, not only for yourself during your lifetime, but for your beneficiaries after your death. Let's talk first about the benefit to you while you are living. Think about an instance where you have a stroke or you are in an accident and you become incapacitated. Without having a trust in place, and also working in connection with the power of attorney that is included in the net law plan, you have put in place the ability for an individual named in your power of attorney and your successor trustee named within the trust that you have selected to be able to carry on and manage your affairs for you without the need of having to go to guardianship court. That's huge. That's a huge benefit to you while you are living. Now, upon your passing, it's a benefit to your family because the assets that are held within that trust upon your death are not going to be frozen by the court. They're not subject to that probate process, which means they're not subject to the creditor's claim period, which freezes those assets for a period of time after your death, thereby keeping those assets out of the hands of your family. So your family cannot access those assets during that creditor's claim period to pay bills and to continue to support the family. If those assets were held inside the trust upon your death, that would not be the case. So this is a great, great way for you to manage those assets and benefit yourself during your lifetime and your family after death. This is also a great way for you to structure the manner in which your beneficiaries receive their assets after death. So the example I like to give is, my daughter, she's 10 years old, and I could set up a revocable living trust today that says when she turns 21, I want her to get her entire inheritance at one time, just outright. She's a great kid. She's a straight A student, never given me days of trouble in the 10 years that, she's been on this earth. And, I want to set that up so that she gets all of her, inheritance when she turns 21. But what happens in 5 years? What happens in 10 years? Well, I don't know, right? None of us do. We hope that as parents that we've raised our kids to be, to grow up to be responsible adults and to manage, their, not only their lives, but their money in a responsible way, but we just don't know. She could very well develop a drug problem. She could very well marry somebody controlling that I cannot stand. And I want to be able to maintain that flexibility and that control and the ability to go in and change the terms of that trust at any time. So I could go back in and amend that trust and lock down those assets to keep them out of the hands of her husband or rather out of the hands of any future ex-husband that she may have, because I want to make sure that those assets benefit my family and benefit my daughter. So that's just a really good way for me to do that, and to make sure that, as life changes, as things happen, I can update that at any time. I can make changes at any time. I can buy and sell real estate outside of that trust. I can, transfer my home into the name of that trust, and then 3 years from now, if I sell my home, I sell it out of the trust and then purchase another trust, a house within the name of the trust from day one, so I don't have to make another transfer. So it's a wonderful, wonderful benefit to me. Now, I want to point out that with this particular type of trust, the revocable living trust, this trust does not give you, the individual that set the trust up, this does not give that individual any kind of tax advantage during their lifetime. So this is not an asset protection trust. What I mean by that is you cannot set up a revocable living trust and move all of your assets into the name of that trust and then file for bankruptcy the next day. And why is that? The reason for that is, again, because you maintain control. You can put assets in, which means you can take assets out. And that's exactly what a judge is going to tell you. They're going to tell you to go get the assets out of that trust and pay your bills. They're not going to protect those assets from creditors or bankruptcy. So it's not an asset protection trust. Also, it does not affect your income taxes either way during your lifetime. This trust maintains your Social Security number and does not negatively or positively impact your income taxes at all. So for tax purposes, creditor protection purposes, during your lifetime, it is as if this trust does not exist. It purely protects your assets from probate and helps you in the event of a disability. So I hope that makes sense. Let's talk a little bit about irrevocable trust now and what the differences are. Now, an irrevocable trust, again, by its name, is irrevocable, just like a revocable trust is revocable. So what do you think that means? An irrevocable trust cannot be changed. It cannot be terminated by anyone other than the terms of the trust itself. So again, I'll use myself as an example. If I set up an irrevocable trust today, and I set that up to say that when my daughter turns 21, I want her to get her entire inheritance outright in one chunk at one time, I can't change that. If she develops that drug problem or marries some loser that I can't stand, I cannot change the terms of that trust. They are fixed. Also, when I move assets into that trust, I can't take them out. I cannot benefit from those trust assets. I can't control how they're managed. I can't control anything. So when you move assets into an irrevocable trust, you are giving up control. You are basically giving up control and benefit to those assets. And you are giving up the flexibility of being able to change that trust. So some people might say, well then gosh, why on earth would anybody want an irrevocable trust? And I'll talk a little bit about that. Much like the revocable trust, an irrevocable trust is private. It's not subject to court jurisdiction. The assets of that trust are not going to be subject to probate. So the terms of that trust, all of that is kept private. It does give you the ability to manage assets for the next generation. This does not give you the ability to manage assets for yourself. You cannot benefit from this trust. These assets, however, can be protected from creditors. And there's some caveats to that. It obviously cannot be set up today and you file for bankruptcy tomorrow, because that would be fraud. There is a look back on that. Basically, and in most cases, it's a 3-year look back. If you set up an irrevocable trust and move all of your assets into the name of that trust, there's going to be a 3-year look back for many things, not only for creditors, but also for federal estate tax purposes. So Keeping that in mind as well, if you move your assets into an irrevocable trust for creditor protection purposes, there is going to be a look-back rule. So if there's any kind of claim filed against you or any kind of legal action filed against you during that look-back period, those assets are likely going to be subject to those creditors. But let's talk a little bit more about just the manner in which these assets are transferred, why you would want to do that, why it has historically been used, and then we can go back and forth and answer some questions about more of the pros and cons as we move along. But historically, irrevocable trusts were used for estate tax planning purposes. This is sometimes referred to as a gifting trust. Maybe you've heard about making annual gifts, and we'll talk about the annual gift exclusion here in just a moment. But once upon a time, the federal estate tax exemption was only $600,000 per person, which for a lot of people, that affected a lot of people. A lot of people were in excess of that amount from an estate planning or estate tax standpoint. So what a lot of people would do would be set up these irrevocable trusts and make annual gifts to that trust to slowly over time reduce their federal estate tax liability, to reduce their taxable estate and reduce that tax liability. So it was used a lot for gifting purposes. It was also historically used a lot for life insurance. And it is still used for life insurance, just not as often because the exemptions are so high. And we'll talk about what those exemptions are here in a moment. But I want to talk about how this is used with life insurance. So an irrevocable trust. Again, that is a trust, and I'll use myself as the example because I actually do have an irrevocable life insurance trust that I set up a long time ago that I am the settlor of. I set it up, but my husband is the trustee. I cannot be the trustee of my irrevocable trust. And why is that? Because I cannot control it, right? You lose control over these assets when you set up an irrevocable trust. So with life insurance, if I have an existing life insurance policy, say it's an old policy that I have that I set up a long time ago, and I decide to set up a life insurance trust today, and I want to transfer ownership and beneficiary of that life insurance trust to, or ownership and beneficiary designation of that life insurance policy to the insurance trust, I can do that. So I can request change of ownership forms and change of beneficiary forms of that existing life insurance policy and make my trust the owner and beneficiary of that policy. When I do that for, again, an existing policy, one that's already in effect, there's a 3-year look back. I mentioned that a moment ago. So for existing policies, when you make a transfer of ownership, there is a 3-year look back rule. So if you pass away within 3 years of that transfer of ownership, the IRS is going to pull that policy back into your taxable estate, and it will be included with any other assets that are going to be taxed upon your death. Now, let's look at it from a different angle. Let's say that you are setting up the insurance trust today because you know that you're going to be taking out a large life insurance policy. So you're going to want to set up that insurance trust first, and then once that trust is in place and it's signed and it's fully effective, fully in place, and let's say that Mary Lennox, Mary's on the call today. Let's say that Mary, you're working with a client and they're getting ready to you're getting ready to place a $10 million life insurance policy, permanent life insurance policy with that client. Well, that's a pretty big policy, right? So what you want to do is make sure that that life insurance trust is set up first, and then you have the trustee of that trust be the applicant, the owner, and the beneficiary on behalf of the trust of that policy. So basically, the trustee named of that trust will sign in their capacity as trustee of the trust as the owner, the applicant, and the beneficiary, so that the trust owns the policy from day one. And the reason that is important is because there's never a transfer of ownership, which means you completely avoid that 3-year look-back rule, and that life insurance policy is never included in your taxable estate, period. Whether that's a $10 million policy, a $50 million policy, or a $5,000 policy, when that policy is issued from day one in the name of that trust as the owner, it will never be included in your taxable estate. Does that make sense? So that's a pretty big deal. That's a pretty big issue. When you're working with somebody on those very large policies, that's a great way for them to never have that included in their taxable estate at all to begin with. Now, that doesn't mean that they can't benefit from transferring an existing policy, especially if they're, in good health and there's no, no risk of, imminent death. There's, still great benefit of transferring an existing policy into a life insurance trust. So keep that in mind too as you're working with your clients, and, hopefully when you're working with those very wealthy clients, make sure that they understand that, this is something that will benefit their family, down the road tremendously, because you're basically saving them about 45% is the top tax bracket on the federal estate taxes currently. So you're saving them 45% in tax on that insurance policy if that policy is owned day one from the insurance trust, or if they transfer it and they survive that 3-year look-back rule. So that's just a great, great benefit. Now, one of the other things to keep in mind here is, again, the ability for you to use this to manage assets going forward for future generations. So you have the ability to set up how you want your spouse to benefit. Then you have the ability to set up how you want your children to benefit upon the second death of you and your spouse. You have the ability to make sure that this stays in your family, benefiting your bloodline, grandchildren, great-grandchildren. There are many states that even allow for what's called perpetual trust, which means that these trusts can exist in perpetuity. They can go on forever, benefiting generation after generation. And why is that important? Why would you even want to do that? Because as long as these assets are held in trust for the benefit of your family, these assets will never be taxed in their estates for federal estate tax purposes, regardless of what those assets grow to during the time that those assets are held in trust. So that is a wonderful benefit. That those perpetual trusts are fantastic for building family wealth for generation after generation. And again, one of my favorite things to talk about is this protects your family from what I call in-laws, that in-law protection. My future ex-son-in-law is never going to get a penny of my daughter's inheritance, ever, because I've made sure that that's not going to happen. He's never going to have the ability to get his hands on it. And likewise for my future generations. So, there's some wonderful benefits to the irrevocable trust from a tax planning standpoint. However, for the person setting up the trust, there are some negative consequences, and those negative consequences are you lose control of those assets. You lose the ability to benefit from those assets. Once you set that trust up, the terms of that trust are fixed and cannot be changed. Whereas with a revocable trust, you maintain full control. You can benefit from those assets. You can change the terms at any time. So those are some of the differences there. Let me continue on a little bit, and then I'll go into some questions here, because I'm sure there's questions that I need to address. So just want to remind you again of where we stand currently today with the credit exemptions, and the credit is unified. We do have a unified credit right now with the estate tax and the gift tax. So basically in 2017, anybody can gift away, either during their lifetime or upon death, $5.49 million. So I could give anybody on this call, I could give Jenny Lopez, I could give Jenny Lopez $5.49 million today if I wanted to, and if I had it, I could do that. So I could either do that during my lifetime, or upon my death, I could say in my will that I want Jenny to have $5.49 million, and there is no federal estate or gift tax consequences from that. That is exempt. So to put it a different way, I could give away $3 million during my lifetime. So I could give anybody on this call, I could give Jim Gilmore $3 million during my lifetime, which means upon my death, I only have $2.49 million left that could be exempted from federal estate tax. So that's how that works. So the gift tax and the federal estate tax, they're a unified credit that you can either use fully or partially during your lifetime or fully or partially upon your death. Now, for married couples, that federal estate tax exemption is portable. So again, using that exemption where I give Jim Gilmore $3 million during my lifetime, let's say that I instead gave him $3 million under my will upon my death. So I've got a federal taxable estate of $3 million. And Jim, I think you're such a great guy. I'm just going to leave everything to you when I die. So when I die, I use $3 million of my $5.9 million exemption, and my remaining exemption could then pass to my husband if he was, still speaking to me after leaving Jim all of my money. But Blake could have my remaining $2.49 million plus his full exemption upon his death. So that's how that portability works. And I want to point out that it's not automatic. You do not automatically get your spouse's unused estate tax exemption upon death. You actually have to file a federal estate tax return, even though there's no tax due, but you do have to file the return. It's a Form 706 federal estate tax return, and elect the portability of that unused exemption so that your surviving spouse can then use that. So I hope that makes sense. I want to talk a bit about the gifting exemptions. I mentioned earlier with the irrevocable trust how historically the irrevocable trust has been used for gifting purposes, for making annual exclusion gifts so that individuals can, slowly over time reduce their federal taxable estate. And I say slowly because it's, depending on how many beneficiaries you have, that can limit you somewhat on how much you can reduce your estate. Unless you just don't care who you make those gifts to, then it's unlimited. So basically, I could give every single person on this call $14,000 this year, and it would not reduce my federal estate tax exemption or eat into my gift tax exemption. So I could give anybody and everybody on this call $14,000 today, and it would not negatively impact my exemptions. And, to that point, for families, a lot of times what they would do is set up these gifting trusts, and they would say that the beneficiaries of that trust would be children and grandchildren. So let's say you've got 2 children, and they each have 2 children. So that's, 6 beneficiaries. So that 6 times 14 is what you could gift to that trust every year. So that's how, over time, individuals would slowly be able to reduce their taxable estate and their federal estate tax liability. Now, again, that's unlimited to anybody, and it can be a stranger. It doesn't have to be a family member. It doesn't have to even be anybody you know. $14,000 to any individual, and that does not negatively impact you. And that can be as many individuals as you like, as long as it's not over $14,000. Now, if you give $14,005, then that $5 is going to eat into your exemption amounts. So that's kind of how that works. Much like the federal estate tax exemption, if you pass away with $5.49 million or less in your estate, there's no estate tax liability. But if you pass away with, $6 million, then the difference there is what's going to be subject to that federal estate tax. Now, you can make unlimited gifts to your spouse. Again, that's either during life or at death, and that can be outright or in trust. So what I mean by that is, and I always like to use Bill and Melinda Gates because they have billions of dollars. So Bill Gates could die today and give all of his billions of dollars outright or in trust to Melinda, and Melinda pays 0 tax. There's no tax on Bill's estate, and that's because there is an unlimited marital deduction. So upon the death of the first spouse, there's no estate tax due because there is that unlimited marital deduction. Now, a lot of times you're going to want to use your exemption anyway so that all of that is not going to be taxed at the second death, but you don't have to if you don't want to. So again, unlimited marital deduction between husband and wife. Now, for anybody else, for kids or other individuals, it's the same as the regular annual exclusion amount. It's $14,000 per person. For charities, for organizations that are qualified 501c3 nonprofit organizations, it's unlimited. So much like a spouse, you can give your entire estate to a nonprofit, to a charity, and there are no estate or gift tax consequences. And again, that can be outright or in trust. So I hope that makes sense. So again, I want to go through the reminders that I mentioned at the beginning of the presentation, and then I'll take some questions. Again, I want to remind all of you that maybe joined late that for your new agents, for agents that sign up with NetLaw for the first time, so not necessarily a brand new WFG agent, but a brand new agent that has registered with NetLaw, for their first 30 days with NetLaw, they have the ability to offer all of their clients a buy one, get one free. Great way for them to get out there and kickstart their career with not only WFG but with NetLaw. I encourage you to, when you're talking to clients about this NetLaw plan and you think it would be a really good team member, to recruit them. Tell them, so if you join WFG, the $100 fee you pay to join WFG, you're basically going to get back when you buy the NetLaw plan, because you get the commission on that plan, and then you'll get a free plan that you can gift to somebody because you're a new agent. So again, going back to that join, own, and share concept, that's a great way for you to build your teams. And so again, make sure that you are talking to all of your new agents about this. As soon as they get their WFG code, what's the next thing that you do? Have them download and register on the NetLaw mobile app so they can get started with this 30-day buy one, get one free offer. Again, want to remind everybody of the March contest. It's a $3,000 cash prize. This is an incredible gift. We have not done this before, guys. So all you have to do to qualify is to refer 5 fully paid plans before March 31st. And then for every fully paid plan over 5, your name goes into the drawing again. And guys, today only, for every plan that you refer, fully paid plan, it counts as 2 towards that contest. So that's today only through midnight tonight Pacific Coast time. So make sure you're taking advantage of that. So I'm going to pull up some questions here and see what is left for me to address. I'm sure there's lots with the subject matter that we've had today. So bear with me a moment while I kind of flip through these. Let me scroll up. And let's see. So Mary, hello Mary, is asking, are there tax benefits, consequences to having a trust, the owner and or beneficiary of an insurance and or annuities? So we talked about that. Hopefully I answered that question as I was going along, and I'm just going to address insurance here. And that is with policies, I'll just reiterate, yes, the federal estate tax benefit for insurance policies is that if that policy is owned by an insurance trust, an irrevocable trust, upon death, and has been owned by that trust for at least 3 or more years, the policy and the proceeds from that policy, any cash accumulation within that policy is going to be excluded from the client's federal estate tax estate, from their federally taxable estate. So now again, a lot of people think, well, they think that life insurance policies aren't taxed. Well, they're not taxed from an income tax standpoint for the beneficiary. It's not an income tax asset for the beneficiary. However, it is a taxable asset for the insured if they own it in their individual name. If it's owned by this irrevocable trust, it's not going to be part of their taxable estate. Again, the key there is they must have that trust own the policy for at least 3 or more years before that person passes away. Hope that makes sense. Ben, I just repeated the join, own, share concept. I hope you're still on to hear that. I think that's a fantastic concept that I've stolen from the field. You guys always have the best ideas. Let's see here, what else? Jeannie's asking, do you have to obtain a tax ID number for a revocable trust? Not for a revocable trust, and that's R-E-V-O-C-A-B-L-E, revocable. The revocable trust maintains your Social Security number. An irrevocable trust, however, does require a tax ID number because it is a separate taxable entity. So a separate tax ID number will be required for an irrevocable trust. Let's see here. Mary's asking here, what happens with an irrevocable trust if the government gets rid of the estate tax? Well, what I can tell you, Mary, is that, what's in that trust is going to be in that trust, period, regardless of what happens with the federal estate tax exemptions. We are currently on our 22nd version of the federal estate tax, and so that's got to tell you something. And what that tells me is we haven't seen the last of the changes in the federal estate tax world. Exemptions are going to go up, they're going to go down, tax rates are going to go up, they're going to go down. There may be a repeal at some point, but guess what? What's going to happen when the next president comes into office or the president after that? So, that's something that I would plan for the worst and hope for the best, in my opinion. Let's see, what else do we have here? The applicant, owner, and beneficiary. So Sandra's saying, is the applicant, owner, and beneficiary the beneficiary you and your husband as the trust, correct? So let me just explain what that is there, Sandra. And again, I'm talking about an irrevocable trust and using that as a mechanism for protecting the policy from federal estate tax. If you are the owner and the insured, then you own the policy, which means that it's going to be included in your taxable estate. To remove that policy from your taxable estate, you would transfer ownership of that policy to an irrevocable life insurance trust, which likely, if you're married, you would name your spouse as the trustee. Likewise, you would probably also want to transfer the beneficiary designation of that policy to that trust. And the reason for that is you want those proceeds not only to be excluded from your taxable estate, but you also want those proceeds to be excluded from your beneficiary's taxable estates down the road. And by doing that, that will accomplish that. Let's see. Let's see here. So Mary's asking, and I think I just answered that. She thought that the payment to the beneficiary was not taxable. You are correct, Mary. Life insurance is not taxable to the beneficiary for income tax purposes. Again, however, if you own that policy, it's going to be taxed for federal estate tax purposes in your estate. It is an asset of your estate if you own it in your individual name. Let's see here. Rebecca, so clients and their descendants can take part of those benefits and they will be non-taxable because they come from the trust. Not quite sure in what respect you were asking that question. I think that was in reference to my point that as long as those assets are held in trust, and again, I'm talking about an irrevocable trust for the benefit of your descendants, your beneficiaries, as long as those assets are held in trust for the benefit of those beneficiaries, they're not going to be included in that beneficiary's taxable estate, regardless of what those assets grow to. They can benefit from those assets, but when they pull assets out, that would then add to their taxable estate. So let's say that I've set up my irrevocable life insurance trust and all of my life insurance is going to be paid to that trust and then benefit my daughter. So she can, use that money from the trust to pay for her mortgage, to put gas in her car, to pay her utility bills, to pay health expenses, what have you. She can, all of that is at her disposal. She can take, depending again on how I have the provision set up, let's say that I give her the ability to take 5% of the trust out of the trust every year if she wants to. She can do that if I give her those rights and that ability to do so. But when she takes that money outright out of the trust, it's then in her individual name. So that if she then takes that $5,000 or 5% or whatever it is out of the trust, it's in her individual name, and then whatever she invests that in or whatever it grows to will be included in her taxable estate. However, if she had made that same investment inside of the trust rather than in her individual name, that investment would not be included in her taxable estate. I hope that makes sense. That doesn't mean that she can't benefit from it. That doesn't mean that she can't take, a monthly allowance, a monthly stipend, yearly, quarterly, what have you, to pay for her bills and to help supplement retirement or whatever the case may be. So that's how that works. Let's see what else is left here. Let's see. So Wei is asking, I have a client who wants to put his 4 kids as life insurance beneficiaries. However, they are all minors, and the client does not want his ex-wife as the custodian for the 4 kids. Should we set up a trust, and what type? I think what you're asking here is he wants his kids to be the beneficiary of his life insurance, but he doesn't want his ex-wife to manage those assets for those kids. So he could use the revocable living trust that is included in the net law plan, and name that trust as the beneficiary of that life insurance policy. And then he can name someone other than his ex-wife as the trustee of that trust that will then manage those assets for the benefit of his children. So that could be another family member. It could be a bank or trust company. He could name whomever he wanted to as his successor trustee to then manage those assets for the benefit of his children. Let's see here. Lots and lots of questions. Sorry, guys. It's going to take me a bit to get through these. If I have 10 million in assets, would I pay 45% on the whole amount or just the amount over 5.49 million? So that's what An is asking. So if you have a $10 million estate and you are not married, you would use and you died in 2017, because the 5.49 million is the exemption amount for 2017, then the amount over 5.49 million would be subject to the 45% federal estate tax bracket, that tax rate. So yes, if you are married and your combined estate value, your combined taxable estate between you and your spouse is $10 million, then you can exempt $5.49 million upon your death, and then your spouse can exempt the remaining amount upon his or her death. So that's how that works. So it's individually $5.49 million. If you're married, that exemption can be portable between spouses, and you can exempt almost $11 million in 2017. Let's see. Oh, George is telling me that he'll take the $14,000 gift right now. I bet you would, George. But you know, it goes both ways. You can also make that gift coming back to me if you want to. So Freddie is asking, does that exemption, and I'm going to address this in 2 ways. Freddie is asking, does that exemption amount and the portability of that exemption only count towards the first spouse? So let's say that, and you guys all know that I'm really fond of doing this, say that my husband Blake dies before me, because you guys know he's going to, right? And let's say that, you know, he passes away with $2 million in his taxable estate. So I can then I can elect portability and receive his remaining 3.49 million. Now let's say that I marry again and that husband dies. Depending on kind of the flow of that, depending on the succession of spouses, there may or may not be limitations to that. I don't want to get in the weeds too much on that one, but there may or may not be some limitations. Now, with regard to the unlimited marital deduction, that is unlimited regardless if it's a first spouse, second spouse, third spouse, fourth spouse, so on and so forth. So that's how that works. So Ram is asking here, not all states allow joint trust. Is there a list somewhere on the NetLaw website which lists the states that allow this type of trust? Actually, a lot of the states do allow joint trust. NetLaw only offers the joint trust in community property states, and that list of community property states is available on the website, and I'll show you in a moment where to access that. The reason we do that is because it's especially important in community property states because of the laws regarding those community property assets and the taxability of those assets. In non-community property states, it's really not an issue. And a lot of times in non-community property states, having a joint trust can cause more complexities and administrative burden from the standpoint of administering the trust after the death of the first spouse, because a lot of times they're just not the assets aren't transferred properly and they're not managed properly at the first death. So that is one of the reasons why, as a company, we do not offer joint trust in all states, but only in the states that are community property states. So I hope that makes sense. Let's see here, what else? So Judy's asking if I could explain again about the attorney's fees. Yes. So I want to make sure that you guys know that When your clients connect with one of our network attorneys, because we do have a network of estate planning attorneys that are available as a resource for your clients. And when I say resource, I mean that, a lot of times when somebody needs to speak with an attorney, they don't know who to turn to. They don't know who is good. They don't know who specializes in this area of law. And so we've taken that guesswork out of the equation. The time and the services that these attorneys provide are not included in the net law fee. There will be a charge, an extra charge. These attorneys, believe it or not, shockingly enough, they charge for their time. And so your clients will have to pay for that time. Also, your clients will need to make an appointment. They can't just call the attorney and expect the attorney to pick up the phone and answer a quick question. That's not how attorneys operate. You'll need to make an appointment for either a phone conference or a face-to-face conference, and you will likely be charged for that. So please make sure your clients are aware of that. Judy, I'll talk about how you get registered with NetLaw here in just a moment. Another person is asking, does NetLaw offer an irrevocable trust? We do not. We do not offer an irrevocable trust through our client product. The reason for that is because it is very restrictive in nature. It's a very complex, complicated document, and we don't want to put anything like that in the hands of a client that will not understand what they're doing and potentially cause themselves some harm. So I think, as you can see from the material that we've covered today, an irrevocable trust is very, very complex. So that is a situation where a client would want to connect with one of our network attorneys if they want to pursue an irrevocable trust. Let's see here, what else do we have? Can another trust be a beneficiary of an irrevocable trust for the purposes of being able to change beneficiaries? No. Cannot. So again, once you change the beneficiary to, well, I say no, you can't. There's a lot of caveats there. There's a lot of if, then this. But basically, in a nutshell, no. Once you make that change, the change is made. There's a lot of special provisions and special drafting that adds a lot of complexity and cost to that type of trust to even give the possibility of having that option. But however, once you transfer ownership, so once I transfer ownership of my life insurance policy to a irrevocable trust, I myself personally can never change that beneficiary. I lose forevermore the ability for me to personally change the beneficiary of that policy. So that's the short answer. Let's see. So Donna's asking, explain the commission and prospecting tips. So the commission on the NetLaw plan is 50% of every dollar we collect on every plan that you refer is shared back with you through the grid. So if you sell a NetLaw plan and the client pays for it in full for $500, we're going to send $250 back to you through the grid. If they're financing that plan, because they do have the option to finance the plan over the course of 12 months for $50 a month, then every month when they make a payment, we're sending $50 through the grid back to you, or rather $25, sorry. They're making a $50 payment, $25 of that $50 is being shared back to you through the grid. Now we do that every Thursday. I want to reiterate that. We send a wire transfer once a week, every Thursday to Atlanta with the commissions that we have collected for that week. Every Thursday, which means I think by Tuesday of the following week is when that comes back out to you through the grid. Now, I encourage you to please look at your statement. If you think that you are not seeing your commission, please check with your upline. If you are not an SMD, it's my understanding if you are not an SMD or above, you have to go through your upline to inquire about your commissions. Now, you can contact us if you want to, just to confirm that we did send it on that Thursday to Atlanta, and that's really all we can confirm. I get a lot of emails. Our support center gets a lot of calls from agents saying, I didn't get paid, and we can confirm to them that on this day is when we sent the commission for the sale of this particular plan to Atlanta. We cannot control what happens to it once it goes to Atlanta. So again, feel free to contact us and we can confirm to you when it went from our hands into the hands of your commissions department. But from there, if you want any more details, you really need to either contact the commissions department directly if you're an SMD or above, and if not, then contact your SMD. Let's see here. What else here? So Sam is saying, my client procrastinated in purchasing the BOGO back in December and January, because we did offer that also in January, and he's been whiny ever since. Well, my goodness, can you imagine a whiny client? I'm sure that, Sam, you're the only one that has that problem. And so Sam is asking, if I'm able to convince him to join and get the BOGO, will I get any brownie points? Absolutely, Sam. I will send you a gold star. I'll give you a pat right on the back for doing that. You get all kinds of brownie points for that. Don't know what brownie points you'd be talking about other than the override on the sale of that plan if he's your downline, and then points and that kind of thing. But so sorry about that. I'll say congratulations and pat you on the back. Let's see. So another question here, somebody's asking, can you get rid of an irrevocable trust and create another irrevocable trust? No and yes. Once an irrevocable trust is created, its terms are fixed. It cannot be changed. It cannot be terminated. However, you could set up another irrevocable trust, but you cannot move assets from one irrevocable trust to another irrevocable trust. You lose complete control over those assets. Let's see. So again, those terms are fixed. Once you set up an irrevocable trust, those terms are fixed. You have no control over that trust. You cannot change the terms of that trust. You cannot change the beneficiaries of that trust. It is fixed. You lose complete control. Yes, these presentations are recorded. We will be sending out an email with a link to the recording today, and this will be put into the archives. Someone else is asking what type of life insurance can be put into the ILET, and basically any kind of life insurance, even a term policy. It doesn't really benefit you. A term policy really doesn't benefit you from. Let me get my thoughts straight here. Sorry. It benefits you from exempting the death benefit in your estate. So that's not going to be included in your estate. But since there's no cash value, there's no benefit from a cash value standpoint. It's just from the death benefit standpoint. But pretty much any kind of life insurance can be owned by a life insurance trust. Let's see. Can a foreigner set up an insurance trust or living trust? Yes, they can. And I'm going to be completely honest with you when it comes to life insurance and non-U.S. citizens. I really need to do some more research on that to see if there are any limitations. So for example, I know that, and I'll go back to that screen here, I know that there are limitations on the federal estate tax exemption for non-U.S. Citizens, and that is for non-U.S. citizens you can only you don't get the $5.49 million exemption, you only get a $60,000 exemption. So I'm not sure if there are any limitations on life insurance. I thank you for that question, and I'll do some research on that. If you wouldn't mind shooting me your email real quick in the questions box, and I will circle back around with you one-on-one to clarify the answer on that. Let's see here. Let's see. So as long as life insurance is under the $5.49 million, it will not be taxed. If you own the policy and that's all you, because remember, it's not just that policy, it's everything in your taxable estate. So let's say you own the life insurance policy and it's $3 million, but then you've got a brokerage account that's worth $1 million, and then you've got a retirement account, an IRA worth, $4 million, and you've got your home that's worth $1 million. All of that is going to be included in your taxable estate. So keep that in mind. It's the total amount of your taxable estate. If your total taxable estate is under the exemption amount, there's no federal estate tax imposed upon death. Let's see. We're running over a little bit, so I'm just going to take a couple of more questions, and then I'm going to conclude. Lots and lots of questions, guys, and I appreciate it. You guys are just being fantastic and hanging in there with me today. Let's see. Lots of the same questions being asked here. Hopefully those have been, you've gotten those answers. Another person's asking, can a trustee of the trust make changes to the trust? No. A trustee, and that's true for a revocable trust and an irrevocable trust. With an irrevocable trust, those terms cannot be changed at all, period. With a revocable trust, only the person that set up the trust can make changes to that trust. Now, the caveat there, the exemption to that is joint trust. So if it's a joint trust, then both husband and wife or spouse and spouse have jointly set the trust up and are jointly the trustee, meaning that either one of them could change a revocable trust during both of their lifetimes. After the death of one of them, then the surviving spouse could only make changes to the trust as it affects the assets that she's leaving to the remaining beneficiaries. So anything that would benefit her could not be changed. Anything that she's leaving and benefiting someone else could be changed. Hope that makes sense. One more question, and then we will conclude. Actually, one more question, and then I'll show you the agent resource page so I can show you some of the things that I mentioned here. Let's see, Jeannie's asking, do I have a list of the state estate tax exemption and portability? The estate tax exemption I was talking about is federal estate tax exemption. There are state estate taxes. However, most of those, again, I'm generalizing here, most of those are tied to the federal estate tax exemption, meaning that unless you meet or exceed the amount of the federal estate tax exemption, generally there is no state estate tax. There's also in some states like Kentucky, a state, and I'm saying state, not estate, a state inheritance tax. So in Kentucky, you've got the federal estate tax, you could potentially have state estate tax, and an inheritance tax. So it just depends on where you live. All right, guys, with that, I'm going to flip to the end here of my presentation, and I'm going to hop off and go into the website real quick. I want to show you the agent resource page and just some of the resources. So again, guys, from here at the top, and this is wfg.netlawinc.com. From the top, you can click here on the $3,000 Spring Fling contest to find out more information about the March contest. New agent information, this is great for your new agents that you are bringing on board. When you click on that, this talks about the new agent buy one, get one free offer for the first 30 days. So please send your new agents to this site. And then also here is the new agent training webinar schedule, which they can register for these, or if they want a one-on training session, they can click here to get a one-on-one training session with somebody in our office. I want to point out the client workshop invitation. Again, that's up here at the top of your screen, client workshop invitation. Let me make my screen a little bit bigger. When you click on that, that's going to give you the upcoming dates for my client workshops. You can use this URL here, copy and paste that into emails, text messages, what have you, to invite clients and prospects to my client workshops. These are hot links here. So by clicking on the date that they want to attend, it'll take them to a registration page to register for that particular webinar. If you have not been through one of those as an agent, they're very beneficial for you as well, so I would encourage you to sit through those. Now, as for resources, if you look under here where it says NetLaw Feed, when you click on that, that's going to take you to a place where you can find archived webinars. So, for example, last week we had Jay Mamie as a guest speaker. He did a fantastic job. Jay, by the way, as most of you know, is our top producer. So he gave some really great tips there. Other archived webinars are here, you can see. And then as you scroll along, there are additional resources. Like right here is a listing of the creditor claim periods for all 50 states. When you click on older entries, you can find additional resources like the probate laws for every single state are listed here. The list of community property states are here, so on and so forth. So, go through these different sections here because there's a lot of great information that you can find. And with that, guys, I want to pull up the contact information again. I want to thank you for hanging in there with me. I know I went way over today, and I apologize for that. But hopefully you got some really good information out of this. And if any of you have any follow-up questions, please feel free to reach out to us. You can contact us at support@netlawinc.com or by phone at 888-604-4789. Again, 888-604-4789, or you can email me directly at cbaumeier, and that's B as in boy, AUMEIER @netlawinc.com. Thanks so much, guys. Have a great Wednesday. Bye-bye.